Judge Carlton Reeves, nominated to serve as chair of the commission. Welcome back. 3 nominees to serve as vice chair: Laura Mate, Claire Murray, and Judge Phil Restrepo. 3 nominees to serve as members of the commission: Judge Claria Boom, Judge John Gleason, who retired from the Eastern District of New York in 2016, and Candace Wong. Congress created the Sentencing Commission in 1984 and charged it with the critical task of promoting transparency and consistency in federal criminal sentencing. The commission has long operated in a bipartisan manner, a reflection not just of the statutory mandate for bipartisan representation among commission members, but also the consensus-driven approach embraced by those who serve on this important body. This commission collects and analyzes data and then employs its expertise to help guide Congress in setting sentencing policy and to guide the federal judiciary in making important sentencing decisions. Unfortunately, the commission has not had a quorum since 2019. As a result, the commission's been unable to update sentencing guidelines or provide clarity on issues confronting judges throughout the nation. Today, we take an important step to remedy that problem. This bipartisan slate of 7 nominees, selected with input from senior Senate Democrats and Republicans, represents our best opportunity to restore the commission's quorum and enable the commission to resume its important work. I'm now going to turn to Ranking Member Grassley before I introduce the Democratic nominees, and then I'm going to turn to Senator McConnell when he arrives to introduce Republican nominees to the commission. In fact, when Senator McConnell arrives, we will defer to him. I know his schedule is such that he'll can only be with us a short time. So let me start by recognizing my colleague and friend, Senator Grassley.
Good morning. Congratulations to each of you. You're being nominated to a very important function that hasn't worked very well in recent years, but we're getting it back up and running again to serve a very useful purpose that it does. It's a bipartisan agency created by Congress over 40 years ago to promote transparency and proportionality in federal sentencing. This mandate works to ensure that the laws are applied equally and that Congress is informed in making evidence-based policy decisions about sentencing. The Sentencing Commission was established and amends sentencing guidelines, which, while non-binding, also assist federal judges in handing down those sentences. Since the end of 2018, however, the commission hasn't been able to amend the guidelines because it lacks the requisite number of commissions for a quorum. Today's slates of nominees, if confirmed, could revive the agency to do what it was set up to do. As the Sentencing Commission's acting chair, Judge Breyer, recently wrote, quote, "A reconstituted sentencing commission is entitled to ensuring fairness and effectiveness of federal sentencing guidelines and policies," end of quote. So with that in mind, I'm looking forward to learning from today's witnesses. At the outset, it's important for our nominees to know that I believe the Sentencing Commission must remain a bipartisan and independent agency. It should be laser focused in following empirical evidence and congressional intent when amending the guidelines or issuing statements. In addition, I expect members of the Sentencing Commission to take on the critical task of implementing the First Step Act. Chairman Durbin and I worked on this landmark criminal justice bill, but because of the lack of quorum, some parts of the law haven't been updated in the guidelines, such as changes to compassionate release. The commission's acting chair noted that, quote, "In the absence of updated policy guidance from the commission, courts have filled the void themselves, but unlikely in a uniform manner contemplated by the First Step Act," end of quote. A consistent and accurate application of law is necessary for building trust and consistency in federal sentencing. and for implementing the First Step Act as intended. A functioning commission is critical in stepping up to the plate, is of course a very hefty task that they have. Getting the First Step Act signed into law requires buy-in from nearly all members of the Congress, the White House, and federal agencies. But since the passage in 2018, a number of federal judges have interpreted the law beyond its intent. I hope today's nominees agree with me on the importance of faithful adherence to our First Step Act and will work to ensure updates to the guidelines reflected the text of the law. As a champion of criminal justice reform, I'm pleased to participate in today's hearing. I thank the chairman for convening the hearing, for the White House for taking into consideration my staff's recommendations, and for our nominees for stepping up to the plate to serve on the Sentencing Commission. I look forward to your testimony. Could I also say something about an Iowan? I also want to welcome Laura Mate to the Judiciary Committee. Although she works for the Sentencing Resource Council Project in the Federal Public Defender for the District of Arizona's office, her home is in Iowa. She worked on the sentencing-related issues and on sentencing guidelines for over a decade, so I know she has experience in this area. I'm looking forward to hearing more from her today about her prospective role on the Sentencing Commission. Thank you.
Thanks, Senator Grassley. I have the privilege of introducing 4 nominees. First, pleased to introduce Judge Carlton Reeves of the United States District Court for the Southern District of Mississippi, nominated to be Commissioner and Chair of the U.S. Sentencing Commission. Welcome back, Judge. Judge Reeves earned his B.A. magna cum laude from Jackson State University and his J.D. from the University of Virginia School of Law. After law school, he began his legal career clerking and working as staff attorney on the Mississippi Supreme Court before working in private practice for 4 years. He then went on to serve for 6 years as an assistant U.S. attorney for the Southern District of Mississippi, where he was chief of the Civil Division, among other roles. Prior to joining the bench, Judge Reeves co-founded his own law firm where he practiced for 9 years. Since 2010, he's amassed immense practical experience in sentencing. Over the past 11 years, he's presided over hundreds of criminal proceedings and handled sentencing for a wide range of criminal conduct. In approaching sentencing, Judge Reeves has been mindful of the need to individually assess specific facts in the case, apply statutory requirements and guidelines, weigh the human element that's always present when considering the interest of victims, survivors, defendants, and safety in the community. As a seasoned trial judge, Judge Reeves is well positioned to lead the commission as chair. I look forward to your testimony today. Next is Laura Mate, who has the distinction of being introduced by both senators, nominated to be a commissioner and vice chair of the commission, earned her undergraduate degree from Kenyon College, law degree from the University of Michigan, began her legal career in private practice, litigating labor and employment law matters for large and small companies and municipalities. Ms. Mate went on to serve as Assistant Federal Public Defender, representing clients who could not otherwise afford legal counsel. Since 2010, she's worked on the Sentencing Resource Council project, providing litigation support and training for public defenders on sentencing issues. Through this project, as Ms. May puts in her committee questionnaire, she has, quote, monitored every amendment to the guidelines manual since 2011, as well as Sentencing Commission research reports, including the annual source book and special data projects. I would note, as my colleague Senator Grassley has, she lives and works in Des Moines, Iowa. Prior to law school, Ms. Mate spent 3 years as a school teacher in East Baton Rouge Parish School System, initially through Teach for America. Ms. Mate has dedicated her career to public service and spent many years studying federal sentencing law and practice. I look forward to hearing more about her experience and views. Also joining us today is Judge Phil Restrepo, nominated to be Commissioner and Vice Chair. Judge Restrepo earned his undergraduate degree from the University of Pennsylvania, law degree from Tulane. He spent 1 year as a law clerk for the ACLU National Prison Project before serving as a public defender at the state and federal levels, went on to start his own law firm, 13 years in private practice, appointed to serve as magistrate judge on the U.S. District Court for the Eastern District of Pennsylvania in 2006, 7 years later, President Obama nominated him to serve as district judge. The Senate confirmed him by a voice vote. President Obama elevated him to the Third Circuit in 2016, once again receiving significant bipartisan support. Judge Restrepo has experience both in the criminal and civil sentencing, criminal defense and criminal sentencing, and displayed a thoughtful and measured approach to sentencing and rehabilitation. And if there's any doubt that he belongs on the Bipartisan Sentencing Commission, I would note that President Trump twice supported Judge Restrepo for the same position. I give him a warm welcome and his family as well. The committee will also hear from Judge John Gleeson, nominated to serve as a commissioner. Judge Gleeson earned a BA from well-known school, Georgetown University, and a JD, that's my alma mater, and a JD from the University of Virginia School of Law, then clerk for Judge Boyce Martin on the Sixth Circuit. Judge Gleeson is currently in private practice in, and I'll mispronounce this, I'm sure, Debevoise, close, and Plimpton in New York City. At his firm, he established an initiative to help inmates serving excessive sentences. Previously served for 22 years as a judge on the U.S. District Court for the Eastern District, a position the Senate confirmed by a voice vote. Prior to joining the bench, Judge Gleeson served for many years as a federal prosecutor in the U.S. Attorney's Office for the Eastern District of New York, where he was at various times Chief of Special Prosecution, Chief of Organized Crime, Racketeering, and Chief of the Criminal Divisions. Judge Gleeson has significant experience in criminal law as a prosecutor and judge, long time respected for his advocacy for fair sentencing, and we look forward to his testimony. Now, right on time, I would like to introduce the Minority Leader of the United States Senate, Senator McConnell.
Thank you, Mr. Chairman. How's that for a dramatic entrance? Right on time, as you suggest. It's my privilege this morning to introduce three extraordinary women for your consideration for the U.S. Sentencing Commission. Rising crime is at the top of many Americans' minds. It's as important as ever for us to confirm strong candidates for the commission. I'm confident that these nominees will hold criminals accountable and enforce law and order. I'd like to start by highlighting the work of my fellow Kentuckian, Judge Claria Hornboom. For the past 4 years, Judge Boom has served as a U.S. District Judge for both the Eastern and Western districts of my state. She's part of a small and distinct class nationwide. Only 2 judges serve in 2 separate districts at once. This role has offered a master class in law and justice. She traveled throughout our state from Pikeville to Paducah to hear cases affecting every aspect of the Commonwealth. It's a position at the height of the legal world, but it's quite different from her first courtroom experiences. Judge Boom got her earliest taste of the American justice system alongside her mother, who worked as a county circuit clerk in rural Appalachia for 3 decades. In a town with only a few hundred people and a county of just a few thousand, court decisions there affected Judge Boom's neighbors in a uniquely personal way. That background gave her a firm grasp on the concept of equal justice under law. To Judge Boom, everyone from downtown Louisville to the hills of eastern Kentucky deserve the same respect in the courtroom. It's a value she's upheld with distinction as a federal judge. And I know it's the mentality she'll bring to the U.S. Sentencing Commission when she crafts guidelines affecting the whole country. I'd also like to introduce nominees Claire Mccusker Murray and Candace C. Wong. Both are outstanding young lawyers here in Washington. Claire was acting Associate Attorney General in the prior administration. She also worked as an Associate White House counsel and counselor to Attorney General Bill Barr. Before that, she served as a career prosecutor at the Department of Justice, a partner at Kirkland & Ellis, and clerked for Justice Alito and for Judge Kavanaugh. She's currently a very busy mother of 5. Candace currently serves as an assistant U.S. attorney here in Washington, where she is the chief of the Violence Reduction and Trafficking Offenses section. She knows her way around the Sentencing Commission, having previously served as an ex officio member during her time in the leadership of the Criminal Division. She clerked for Justice Sotomayor and, like Claire, for Judge Kavanaugh. If confirmed, she would also be the first Asian American to serve on the Sentencing Commission. Both Claire and Candace bring years of criminal law experience to this role. They're dedicated to the Constitution and fully prepared to uphold the rule of law. So, Mr. Chairman, I know these three women are right for this role, and I expect you'll find them informed, intelligent, and well prepared for today's hearing. So thanks for the opportunity to give me the chance to introduce these fine candidates. I look forward to their continued service to our country. Thank you so much.
Senator McConnell, your presence in the committee is an honor. Thank you for being here and for introducing these worthy nominees. We look forward to working together on a bipartisan basis. And now I would ask the nominees if they would please approach the table. We're setting up the microphones for each. If the nominees would please remain standing, I'll administer the customary oath of the committee. Please raise your right hand. Do you affirm the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record reflect that all the nominees, thank goodness, answered in the affirmative, and please be seated. You'll each have 5 minutes to introduce family and friends if you wish and to say a few words, and we'll start with Judge Reeves, nominated to serve as the committee chair.
Thank you, Senator Durbin and Ranking Member Grassley. I want to first thank the President for nominating me to this position. It's indeed an honor to have the opportunity to work along with these great people on this commission. 12 years ago, I was before this committee in a different capacity. My wife was with me, Laura, and my mother, she was with me as well. But they have all, both of them are now gone. It stings me every day not to have Laura with me in an earthly presence with me for this experience that she's been with me all of my life as a professional. My brothers, Tony and Calvin, are back home watching, but I do have my sisters here, Carolyn, Christy, and Terry, and my daughter, my lovely daughter, who I love dearly, is here with me as well, and that's Shanda. I also have my other family with me. My colleague from my court, Judge Lou Garola, is here, and that means so much to me. He represents the Southern District of Mississippi, and we're so proud and glad that he's here. But I also have some former law clerks who are representing my law clerk family, and I think that I have the best law clerk family that any judge could ever have. And that's Alicia Netterville and Alyssa Johnson, and an incoming law clerk, DeMonte Morgan. To all the people of Yazoo City who supported me, to all my nieces and nephews, thank you for everything. To the Mosley family, the McGee family, the Thomases, Reeves, all of them are taking a proud moment with me and sharing in this experience. And I certainly thank you all for the opportunity, and I welcome your questions.
Thank you, Judge. Next, Ms. Laura Mate.
Thank you, Chair Durbin and Ranking Member Grassley, for scheduling this hearing, and to both of you for the very kind introduction as well. I also want to thank the entire committee for considering my nomination. I'd also like to express my deep gratitude to President Biden to nominating me for this position. I'm very grateful to family, friends, and colleagues near and far for their love and support. With me here today is my amazing mother, Nancy Mate. Also, Brent Pattison, a wonderful husband, father, and juvenile court judge in Des Moines, Iowa, where, as Ranking Member Grassley explained, we live. My daughter Frances is here, and whether I'm ready or not, she is now officially a senior in high school, and I'm grateful for her being here. My father, William Mate, a retired Methodist minister, is recovering from surgery and couldn't travel here today from Minnesota. I'm so grateful to appear before you today, and will do my very best to answer your questions.
Thank you very much. Ms. Murray?
Thank you, Mr. Chairman. It's an honor to be here today. I'm very grateful to you and to Ranking Member Grassley for scheduling this hearing. I'd also like to express my gratitude to Leader McConnell, both for this kind introduction and for recommending me to the President. And I would, of course, like to thank the President for the honor of this nomination. I'm very proud to introduce my family, some of whom are here with me today. First and foremost, I have with me my incredible husband, Michael Murray. I truly won the spouse lottery. Mike and I have 5 kids, as you heard. 4 of them are here at the hearing, and all of them have been bribed with ice cream for good behavior. Our oldest, Julia, is 10 and just finished 4th grade. Nicholas is 7 and is in his final weeks of 2nd grade. Caroline is 5 and is missing her end-of-year kindergarten picnic to support her mom today. And Luke is 3 and just finishing his first year of preschool. Last but not least, Andrew, who is 1, is at home, undoubtedly doing his best to destroy the house. I'd like to express my heartfelt thanks to my in-laws, Frank and Linda Murray, both for raising my husband and for watching baby Andrew during today's hearing. Also with us today are my parents, Susan and Lex Mccusker. I owe them more than I could possibly say, and I'm so grateful that they could be here. I also have one wonderful younger sister, Mallory, who is multiply mentally disabled and so was unable to be here. And my maternal grandparents, Alexander and Virginia Buckwald, who are 96 and 98, are watching the live stream from home. Thank you so much to the members of this committee for considering my nomination. I look forward to your questions.
Thank you very much, Ms. Murray. Judge Restrepo.
Good morning, Chairman Durbin, Senator Grassley. Thank you very much for convening this hearing. I'd like to thank the President for nominating me to this position. I very much look forward to working with my colleagues in a very bipartisan way to advance the goal of the United States Sentencing Commission. Well, with me here today is my wife, Kathy, 3 of my children, Catherine, Andrew, and Matthew. My youngest is involved in an internship in New York City and couldn't join us today, but he's probably watching, I would hope so. His name is Nick. My brother is here, Dr. Nick Restrepo, my sister, Trish Loria, my niece, Christina, and my father-in-law, Gene Mayer. Thank you again for convening this hearing, and I look forward to your questions.
Thank you. Judge Boom?
Thank you, Chairman. I want to thank President Biden for nominating me, Leader McConnell for supporting my nomination and his warm introduction. Thank you, Chairman Durbin and Ranking Member Grassley for holding this hearing, as well as all members of the committee. In my first nomination hearing about 4.5 years ago, I think I set a record for family member attendance, about 16 or 17 of us from Kentucky. Today, we've scaled that back a little bit, but I do have some very important people to introduce. First, my husband, Denny, is with me. He is the humble, quiet strength behind everything we do as a family. We have 2 of our 3 daughters with us today, our twins, Abby and Emma. They just completed their freshman year of college. They are kind, serious students, and they are Division I volleyball players at their respective colleges. Our oldest daughter, Sarah, slightly older by about 14 months, cannot be with us today. She's studying and traveling abroad. She just completed her sophomore year of college. So we are newly empty nesters and, quite frankly, enjoying it. There are some really important people I want to thank who could not be here today. Also, we have our family member, Ben Finkel, who is with us as well. I'm sorry, a family friend. But I want to say thank you to my parents who are watching from my hometown in rural eastern Kentucky, Inez, Martin County, Kentucky, Carolyn and Everett Horn. They gave me the gift of unconditional love, a thirst for education, a keen sense of fairness, and really just set me on a path to be the best I could be and set high expectations for me, and I'm grateful for that. I want to thank my in-laws in California and Oregon, as well as the rest of my family in Kentucky and Georgia as well for their support, along with my law clerks for helping me prepare. So I'm honored to be nominated, and I look forward to answering any questions you may have.
Thank you, Judge Gleason.
Thank you, Chair Durbin, and good morning. And thank you and good morning, Ranking Member Grassley. It's a privilege to be here. I'm deeply honored and humbled by President Biden's nomination of me. I'm equally honored and humbled to be here before this committee. Thank you for convening this hearing, Chair Durbin, and I look forward to answering the committee's questions. My other confirmation hearing was 28 summers ago, and my daughter Molly, my older daughter Molly Elizabeth Gleason, who was then an infant, slept through the whole thing. She's promises to do her best this time. My wife Robin, Paul and William, and sisters are here in spirit, and I'm grateful for that. Today by Zach Sizemore, a friend from my firm. Deb, perfectly. Thank you.
Ms. Wong.
Ranking Member Grassley, thank you for convening today's hearing. I want to thank the Commission. Express my gratitude to recommending me to the President. And the Yahweh raised in law, and they Taiwanese America, who has made the trip from New York. Also here is my husband, Alex, and our two children, Chase and Avery, also who have been bribed with ice cream. Chase would like $5.25. Avery is 2. I've been blessed with many wonderful experiences in my career, but without doubt, being their mom is the greatest. Thank you again for this extraordinary privilege.
Thank you. An amazing array of talent, strong resumes, beautiful families. Thank you all for being here. We're lucky that you're willing to in pursuit of public service. And this is an awesome responsibility you'll have on the Sentencing Commission. We created this commission and gave it, charged it with some pretty lofty goals to be an end to reduce studies, promote transparency in sentencing, establish guidelines for the executive branch, collect and disseminate data on federal sentencing, looking fairness in criminal sentencing in our courts. And luckily for me, I've been given 5 minutes to ask 7 people questions. I have 12 pages of questions to go through, so this quick. In fairness to my staff, I'm going to ask a generic question and allow each of you to give brief responses, if you wish, to one or more aspects of the question. Sentencing is one of the few official activities in our democracy where one American sits in judgment and is empowered to make it that affects the liberty of another citizen. Except in rare cases, how accurate judges are in detecting guilt, remorse, likeliness of recidivism, and the like. And secondly, I guess one of the other aspects of your responsibility will be in determining whether sentences are appropriate to the crime. Questions we have to was the appearance of something called crack cocaine, and it scared the hell out of us. We thought it was too cheap, too addictive, too dangerous to leave alone. And so as a member of the House of Representatives, I voted for a sentencing disparity between crack cocaine and powder cocaine of 100 to 1. Our goal was to make it clear to America that this was the most serious crime, and our hopes were that it would deter the spread of this narcotic. We expected the price of this narcotic, crack cocaine, to go up. It went down. We expected the number of people using crack cocaine to go down. That number went up. We filled the federal prisons with thousands and thousands, primarily of African Americans who were convicted of those crimes. And only recently, relatively recently, did we repair that damage. So you see, Congress doesn't get sentencing right all the time, and that was an illustration of it. So I've hit a softball, or pitched a softball to you, and I'll let Judge Reeves start. Would you like to make a brief comment on your thoughts of what I've just said?
Thank you, Senator Durbin. I think judges are in a unique and excellent position to evaluate whether or not a sentence is necessarily sufficient for the particular offense, because in many instances, all sides are represented. The government is represented by the AUSA, the defendant is represented by an able defense counsel, but the court also has at its disposal the neutral arbiter in that whole thing, the probation office. And there's a lot of information that is gleaned from those competing sources that help drives a judge to get to the appropriate sentence for that appropriate defendant for that appropriate crime.
Ms. Mate?
Thank you, Senator. In what you said, I noticed two things. One, that judges are faced with this very difficult decision to make in sentencing an individual. And this body, in setting policy, is making really tough decisions about what to do on a policy level. I think that's where the commission can be incredibly helpful to both judges and to this body in being that expert body, in collecting data, pursuing the research, hearing input from a wide variety of sources, and collaborating as a body to then make recommendations both to individual judges in the form of guidelines and to this body in the form of reports and recommendations.
Thank you. Ms. Murray?
Thank you, Senator. I was going to say something very similar, which is I think the commission has a number of tools at its disposal that hopefully, if we're fortunate enough to be confirmed, we could be useful to you and hopefully also to sentencing judges through our research arm, through our outreach arm, through the power of convening hearings, to gather sophisticated research to help both Congress and judges in their role. Thank you.
Thank you. And I might just interject. I recently reread the report on child pornography issued by the Sentencing Commission last year, challenging Congress to update the standards of sentencing guidelines, sentencing rather, in the law. We have not accepted that invitation because it's a hard assignment, but we have to play a continuing role working with the commission. Judge Restrepo.
Thank you, Chairman. Sentencing is by far the hardest thing I ever had to do as a judge, and I think most of my colleagues that have been in that position would agree. The guidelines are really helpful. Judges lean heavily on the guidelines, notwithstanding the fact that they're not mandatory anymore. They lean heavily on the research the Sentencing Commission provides judges and the guidance the Commission provides judges. And so I look forward to working in a very collaborative nature with my colleagues here in a bipartisan way to advance the goals you identified earlier.
Thanks. Judge Boone?
Thank you. I agree with Judge Restrepo. Sentencing is the toughest thing we do as district court judges, and arguably the most important. Making decisions about whether and for how long someone's liberty will be taken is an awesome responsibility and a humbling task. Congress has given sitting district court judges two important tools to ensure fairness, transparency, and predictability in undertaking that awesome responsibility, the guidelines and the 3553A factors. So I care deeply about the goals of the Sentencing Reform Act as a citizen and as a sitting judge, and I'd be grateful if I'm fortunate enough to be confirmed to ensure the goals of the Sentencing Reform Act are met and sharpened. Thank you.
Thank you. Judge Gleason?
Thank you, Chair Durbin. I would suggest respectfully, you shouldn't be too hard on yourself for policy decisions that were made back in the 90s. We live in the times we live in. We make policy in the times we live in. One great accomplishment of the Sentencing Reform Act was to create the commission that we all hope to be part of. And I agree wholeheartedly with Senator Grassley. You know, an entity intended to make data-driven, to collect information from all the stakeholders and inform this body, your body, the Congress, and to the extent the commission itself, through the guidelines, creates policy, to do that on an informed, educated, bipartisan basis. Thank you.
Ms. Wong?
Chair Durbin, I care deeply about the sentencing guidelines, and I do believe they play a fundamental role in helping reduce unwarranted sentencing disparities and promoting the type of proportionality in sentencing that you discussed. These are difficult issues, and our system works best with an active, invested Congress paired with a functional commission that can provide research, data, and all that expertise that I know the commission can bring to bear as a clearinghouse of critical sentencing data throughout the country. And I look forward, should I have the great fortune to be confirmed with my fellow nominees, to working with your office and all the other offices on how we can come up with evidence-based improvements to our justice system and help ensure that it is truly delivering the highest quality of justice.
Thank you, judges and judges-to-be, as well as members of the future members of the commission. I thank you for your responses. Senator Grassley.
Yeah. On my first question, since Senator Durbin and I worked together with Senator Lee on writing that act, the First Step Act, I'm going to ask Senator Durbin if he finds anything wrong with this first question to let me know. But it's one of two big issues that I want to ask you. So I have concerns about activism in implementing the First Step Act. Senator Durbin and I spent a long time negotiating the bill, 3 or 4 years. I'm concerned about attempts to rewrite it because of policy disagreements with compromises that we had to make to get the bill with the majority get passed, even get the majority leader to even bring it up. So I'm asking for a commitment to implement the First Step Act as Congress wrote it. Now, it's pretty difficult for you folks sitting there not being involved in this to know just exactly. So I guess I'm really just asking for a good faith effort on each of your parts to look as best you can to everything that went into writing the act, to compromising to get it passed, and to carry it out pretty much as written. And I know most of you are going to say, well, you look at the statute and go from the statute, but I think this is a case where you got to kind of go deeper to know what we had in mind and what we accomplished. So I'm interested in a commitment on your part to implementing the First Step Act. I guess I'd like to have a yes or no from the 7 of you, or if you have some sort of reservation about my request, to expect that to reflect or to state that reservation. So we'll start with you on the left here.
Right. Thank you, Senator Grassley. No reservations here. I expect to be working along with my colleagues here, trying to get to consensus on most things. So I'll be working with the rest of them, and I expect most of them will have no reservations too. And I'm not speaking for them, though.
Ms. May.
Thank you. I agree with Judge Reeves. In the past, the commission has historically addressed new legislation pretty quickly after it passes. It hasn't been able to do that this time, but that's usually primary on the commission's agenda. And of course, the commission is obligated under the statute to do that consistent with everything in Title 18.
No reservations, Senator Grassley. I feel strongly that Congress is the policymaker and that it is the Commission's role to implement Congress's intent.
Likewise, Senator, no reservations.
Senator, I have no reservations whatsoever.
Senator, first step was an amazing accomplishment. Thank you for it, you and your colleagues in the Congress for it. And you have my unqualified commitment to implement it in accordance with both the letter and the spirit and the history of the legislation.
Senator, I have no reservations.
Okay. My second issue, the commission hasn't had a quorum for a number of years. In that case, in that time, the circuit courts have had conflicting interpretations of several guidelines. They've also invalidated some guidelines and concluded that comments were inconsistent with the guidelines. So I want to know if you can make it a priority to address circuit splits, guidelines that have been invalidated by a court, or comments that have been struck down.
Thank you, Senator Grassley. If I am confirmed, I will work with the commissioners and to see what will be the priorities of the commission. But I can assure you that one of those will be to make sure that we deal with the circuit splits, because that is a troubling matter.
Thank you. I agree with Judge Reeves again about the need to work collaboratively with this group in setting those priorities. And again, historically, the Commission has established as priorities circuit splits on guideline interpretation issues, and I don't see that being a problem this time around either. Thank you.
Absolutely, Senator. I think that resolving circuit splits should be a top priority.
I'm very sensitive to this issue as a circuit judge, and I do agree that we need to address this immediately.
I agree as well. What springs to mind as a priority as well, I believe that you mentioned, is updating the guidelines in light of the changes to the law with the First Step Act. There are some provisions, as you mentioned, related to compassionate release that circuit courts, including the Sixth Circuit where I sit, have held that the policy statements are no longer applicable given the changes in the law, changes to the safety valve, and other changes that need to be updated. So I look forward, I hope, if we're fortunate enough to be confirmed, to work with Congress and the commissioners in updating those provisions.
Senator, yes, I agree with your assessment of this as a priority for the newly populated commission.
Senator, I also agree, and would just note that the Supreme Court had several cert petitions recently highlighting divisions within the lower courts, similar to what you mentioned, and specifically called for a commission that could assist in the resolution of these issues.
Thanks, Senator Grassley. Senator Feinstein?
Mr. Chairman, I was thinking back. I actually served on the California Women's Board of Terms and Parole, and we set the sentences in California for women convicted of felonies, and the commission still does, I'm sure. But I just want to say to all of you, it is a real change in how you look at things when you go to a prison and you have people before you and you make a sentence determination. California has a low and a high sentence for crimes, 6 months to 14 years. And so you have to take recidivism into consideration and a number of other things. And I was just thinking back on some of the days in holding the hearings out at the state prison. And it's a tough, tough job. So I just want to wish you well. But part of the mission is really to address the fairness in federal criminal sentencing. And when the commission adjusts the sentencing guidelines range for a criminal offense, the commission has the authority to determine whether the new guideline applies retroactively. And this is an important decision by the commission because the retroactive application of changes to the sentencing guidelines would allow some people who are currently incarcerated to seek reductions to their sentences through a court process. So here's the question to all of you. Beginning with Judge Reeves, if you were confirmed to the commission, what is the analytical process that you would use in determining whether an amendment to the federal sentencing guidelines should be applied retroactively?
Thank you for the question, Senator Feinstein. One of the things that I would do is, again, work along with my colleagues here and with the staff of the Sentencing Commission to get the data, to get the things, to get information from the various stakeholders that are involved in the criminal justice system, including the probation office, including the Bureau of Prisons, including the government, the U.S. attorneys, or the Department of Justice and the public defender. The public defenders, have all the stakeholders, and again, have hearings, have information to determine whether or not each, when there is a new law, whether it would apply a retroactive in taking the resources and the data that we would be requesting from these stakeholders.
Please, go ahead.
Thank you, Senator. When looking at the retroactivity issue, I think impact matters a lot. And by impact, I mean the data, the numbers, how many people are affected, but also hearing from a wide variety of people about the impact the change would have for them personally, for their families, for communities, as well as the stakeholders in the system and how they would go about doing something like that. I remember with the drugs -2 retroactivity decision, that one of the adjustments was to the timing of it to make sure that probation officers and courts could be adequately prepared to deal with the changes that were coming their way. Thank you.
Thank you. I agree with everything that's been said. I think the first touchstone in retroactivity decisions should, like in everything else, be congressional intent. So I think you would go very case by case and look first at the change in law that potentially prompted the change in guidelines, and then after that, there are a number of competing considerations. There are considerations of justice. There are considerations of not wanting to undo bargains that may have been made during the plea process. And certainly the inputs you would look at are the ones that my fellow nominees have just put forward. Thanks.
Thank you, Senator. I agree with my colleagues. I would also...
Directly into the mic, please.
Yes. Thanks for the question. I would agree with my colleagues. And I would also solicit the input of the judiciary as well, and to get their perspectives on these issues. And I look forward to working collaboratively in a very nonpartisan way with my colleagues to come to the right conclusion.
Thank you. On any issue of retroactivity, I would want to make sure that the Commission is working within its statutory authority, examining congressional intent as well, and of course studying the data and getting the best input possible from all the relevant stakeholders. So I don't have much to add to the comments of my fellow nominees, but I think all of those steps are important to study the data, recidivism rates, and then ultimately make a reasoned and informed collective and collaborative decision.
Thank you.
Thank you, Senator.
Raise your mic, please.
Yes, I'm sorry. I agree with my colleagues. In addition, I would add that it's a reconciliation of the fairness of applying a reduction to people who previously were sentenced on the one hand, and then the administrative concerns on the other, the length of the reduction, how many inmates would be eligible for it, the burden that would impose on the process. And I think the Commission, those retroactive reductions to the crack sentences in 07 and 10, I think they were handled very prudently by the Commission to achieve that reconciliation of the tension between fairness on the one hand, but on the other hand, it needs to be administrable. Thank you, Senator.
Senator, I'd echo many of the insights of my fellow nominees, and I would just note that the Commission's rules and practices specifically also address some of the procedures the commission should follow. They do note, given the strong interest in finality in the criminal justice system, that the commission guideline changes should generally apply prospectively, but recognizing that retroactivity is something that would be addressed case by case, call for a commission retroactivity impact analysis as well.
Thank you. Thank you, Mr.
Thanks, Senator Feinstein. Senator Blackburn.
Thank you, Mr. Chairman, and congratulations to each of you on your nominations. Judge Wong, I think your children are adorable. And I commend your husband for being here to help you with them today. They are adorable. Judge Gleason, I want to come to you. And let's look at U.S. versus Dossie. And you have frequently criticized sentencing guidelines. And in this case, you criticized using mandatory minimums against defendants you believe were low-level drug traffickers, even when they had been convicted of trafficking large quantities of drugs. In 2016, written testimony to the Judicial Conference of the United States, you also wrote that you believe that the American criminal justice system is, and I'm quoting you, arguably the most punitive one in the world, end quote. So we are right now seeing a rise in violent crime. There is a spike in murders. We have unprecedented numbers of drug deaths, drug traffickers. So how can you possibly say that more lenient sentencing and reduced penalties for convicted criminals is the answer to our crime problems we're facing?
Thank you, Senator, for that question. I haven't said that. I have pointed out, because I think it's useful to policymakers, this body, the Sentencing Commission, from the perspective of a district judge, I have endeavored to point out how mandatory sentencing is inevitably in tension with the individualized sentencing that our system contemplates. I don't purport to make, I didn't when I was on the bench purport to make policy. I did seek to point out how...
Well, I'm going to interrupt you right
Sure.
here, if I may, because I am pulling things that you have written and statements that you have made. Let me move on, Ms. Mate. You have written, in 2013, you wrote a letter to the Sentencing Commission, and you requested that they emphasize a list of priorities. On that list, you included studying and revising drug guidelines, prohibiting the use of acquitted conduct, and narrowing the scope of the career offender guidelines. So now that you're nominated to the commission, are these issues still favored priorities with you? And how would you try to implement them as vice chair of the commission?
Thank you for that question, Senator. That letter was written by a group of people to fulfill the obligation of defenders to comment on the work of the Sentencing Commission. So that was the defenders' list of priorities at that time.
Do
So
you still hold to that list?
I'm not coming in with a list of priorities for this
Changed your
commission.
mind on those?
It's not a matter of changing my mind, Senator. That was the defenders' priorities. I think some of those
But
topics.
you agreed with them in writing and signing the letter, correct?
Yes, in my
Okay.
job with the.
All right, let me move
defenders.
on then. 2020, during COVID, you made the statement, allowing the disease to rage unchecked in prisons is a far greater threat to public safety than lowering prison populations. So let me ask you this. Under what circumstances do you believe it's appropriate to release convicted criminals to protect them from COVID-19?
Thank you for that question, Senator. Again, that document was prepared by Sentencing Resource Council on behalf of defenders, and it was a short fact sheet to provide defense lawyers and decision makers with information about what was happening with COVID-19 in the prisons at that time. It was, I believe, soon after this body had passed the CARES Act. So there was a decision by this body that people needed to be released.
Do you still agree that in a time of pandemic that convicted criminals should be released back on the streets to avoid infection.
I agree with this body's decision in the CARES Act that there
Okay.
can be responsible
All right.
release.
Thank you. Judge Reeves?
Yes, ma'am.
Yes, judicial activism. I'd like to discuss that with you. In an October 2016 interview, you said, and I'm quoting you, "There are sometimes cases that demand public attention. That gives a judge an opportunity to use his or her voice. Additionally, you've sometimes framed Justice Thurgood Marshall's career as a jurist who had a mission to transform the understanding of the Constitution from its original meaning. When you spoke at the 2017 Thurgood Marshall Symposium at Samford University, you said, and I'm quoting, "Today we can all agree that when we look at and think about that document, our concept of it is vastly different from what the men in Philadelphia envisioned. Our concept of what the Constitution is and what it ought to be has been shaped by the advocacy of Thurgood Marshall," end quote. So this was after you testified to this committee during your confirmation hearing in 2010 that the Constitution was not a living document and that it is circumscribed by its text. Should a judge seek cases and make decisions in accordance with how they desire the Constitution to be interpreted?
No.
Thank you. And so what cases demand public attention? What type cases?
At that lecture at Samford University, we were celebrating the 100th anniversary, I believe, of Thurgood Marshall, one of the greatest justices that has sat on the Supreme Court. And in the context of that talk, we were talking about the original Constitution that left out people who look like me, the three-fifths compromise and otherwise. And we talked about the living Constitution in the sense that there was a 14th Amendment and that Thurgood Marshall used that 14th Amendment to sort of crush this notion of separate but equal. The separate but equal doctrine had done so much damage, I believe, to our country because it cast out of we the people a whole section of the population of we the people. So I don't think it's necessarily a living document, and I don't think you should be a mission, but the 14th Amendment means something. And we were celebrating Thurgood Marshall.
Clarification. I appreciate that. Judge Boom, I'm going to come to you separately for something later. Thank you, Mr. Chairman.
Thanks, Senator Blackburn. Senator Padilla.
Thank you, Mr. Chair. Judge Restrepo, you've been involved, as I understand, with the Eastern District of Pennsylvania's Supervision to Aid Reentry Program since 2009. I guess it's referred to as the STAR program. You've also advocated for an approach to criminal justice that allows, or that helps, I should say, offenders to re-enter society more successfully. Right? Part of the objective here is to reduce recidivism, reduce rates of reoffending, and specifically with the help of hiring and mentoring services. I think most of us would agree that a key function of our criminal justice system is to ensure that folks who are convicted of a crime are not only punished, but are also properly rehabilitated for when they return to community. Just to ask you to take a minute to describe in a little bit more detail the work of the STAR program and how that work can help inform the work of the Commission.
Thanks for the question, Senator. I've been involved with STAR, also known as Reentry Court, in the Eastern District of Pennsylvania since about 2007. It's a program that was the brainchild of the Board of Judges in an effort to reduce violent recidivism in Philadelphia. The program targets high-risk violent offenders who've served significant federal prison time coming home to Philadelphia. We meet with the participants every 2 weeks, and we provide help, encouragement, and services needed to make successful reentry back home. It helps them, it helps their families, it helps Philadelphia, it helps all of us. We've enjoyed a good bit of success. Our recidivism rate is well below the national norm for a similar demographic. Among the services we provide are housing assistance, GED tutoring, CDL, tutoring, and just a lot of positive reinforcement and a sense of community that offers these folks coming home an alternative path.
Thank you. And I also couldn't help but note that you were initially nominated to serve on this commission by former President Trump. Your presence today speaks to your ability to garner support from both parties. We call it reaching across the aisle here in the Senate. And in a foreword for a book by the late Judge Harold Baer, you noted that our country has a higher percentage of folks incarcerated than any other in the world. And you specifically mentioned that these numbers are concerning and should not be a partisan issue. So what thoughts do you have concerning the need for judges and prosecutors to be measured and purposeful when considering sentences for those accused of crimes, and especially nonviolent crimes?
Well, I think judges and prosecutors must be mindful in terms of what the responsibilities are and who the person before them is. That was a quote from a foreword I wrote to a book, and the numbers are what the numbers are. But I believe in working collaboratively and trying to find common ground with folks in order to address these really critical issues.
Okay. Thank you. Thank you, Mr. Chair.
Thanks, Senator Padilla. Senator Cotton.
Unfortunately, this country is in the midst of a crime wave, to include a violent crime wave involving gun violence. Most gun crime, like most violent crime, is committed by serious repeat offenders. So I'd like to ask each of the nominees today, is a convicted felon illegally possessing a gun a serious offense? Judge Reeves, we can start with you.
It is.
Ms. Mate.
Yes, it is.
Ms. Murray.
Absolutely.
Judge Restrepo.
It is.
Judge Boom.
It is a very serious offense.
Mr. Gleason.
Yes, Senator Cotton.
And Ms. Wong.
Certainly.
I'm glad that we agree that it's a serious offense, since it's the source of so much gun crime in this country, to the point that in some major cities we get gruesome death tolls every Monday morning of the violence that was committed over the weekend. So I see some of you nodding your head. I think it's happening regrettably in some of your cities. The average sentence for all federal gun crimes is barely 4 years and 3 months to be exact. Do you believe that armed felons should face longer sentences or shorter sentences? Again, I'd like to ask everyone that question. We can start with you, Judge Reeves.
I guess it would depend on what the facts are. In sentencing, it is an individualized matter, so it just depends. I mean, because a felony in Mississippi, for example, could be writing a bad check, and if that is a felon, and it could be, that person does not have the right or permission to own a firearm in the future. But if a person who wrote a bad check, is that person necessarily a violent felony? So sentencing is such an individualized thing. I can only say that it depends on the circumstances, Mr. Senator. They may.
On the second question, I'm sorry, Senator, which?
Should sentences for armed felons be longer?
Thank you, Senator. I think it's a complex issue that judges have to decide on an individualized basis based on the statutory purposes of sentencing. If I'm fortunate enough to be confirmed as a sentencing commissioner, looking at it from the commission's perspective, to answer that question on the range of offenses that would fall within that, I would think we would need to work collaboratively together to gather data and research to inform a recommendation on that.
Ms. Murray.
Weapons offenders have the highest rate of recidivism of any set of federal offenders, and I think these are serious crimes that warrant serious sentences.
Judge Restrepo.
Senator Cotton, it's a difficult question to answer in the abstract. I think every judge has to factor in the information they're given by probation, take a look at the prior record the individual has, the circumstance of the offense. So it's a difficult question, but I understand your concerns.
Judge Boom.
Firearms offenses are some of the most egregious crimes that we see, and they must be met with equally significant consequences. The recidivism rate for firearms offenses is the highest at, I believe, 69%. Just the presence of a weapon, whether or not it's discharged or not, magnifies the risk of harm to the community. The guidelines and the 3553A factors give judges tools to adjust for those. At the end of the day, the court must individualize the sentence, so it's difficult to answer your question in a yes or a no, but certainly I follow the facts and the law in every single case in making that important decision.
Judge Gleason.
Senator, any federal felony that involves a firearm is a serious crime, period, full stop. The answer to your question is a little more complicated. I spent 10 years of my life investigating and prosecuting violent federal crimes, Cosa Nostra crimes, other gang crimes, and that category of defendant covers too much territory to answer your question categorically about whether the average sentence ought to be increased. But I get you, and without qualification, I'll tell you, those are very serious crimes.
Ms. Wong.
Senator, I understand your concerns. I prosecute violent crimes. I work with the victims of violent crimes. I care deeply about making our community safer. Consequences for gun violence should be serious, and obviously that determination in an individual case will turn on the individual facts.
Thank you. Thank you all.
Senator Coons.
Thank you, Chairman Durbin, and thank you for convening this hearing, and congratulations to each of you on your nominations. The Sentencing Commission has an absolutely critical role to play in our federal criminal justice system through rigorous analysis of complex data, receiving comments, holding public hearings. The Sentencing Commission sets the guidelines that shape or guide how courts navigate complex questions of justice and mercy, of punishment, deterrence, and rehabilitation. The need for a working sentencing commission is not a partisan or ideological issue. I thought it was telling that Justice Barrett and Justice Sotomayor, in an opinion issued earlier this year, expressed their hope that a quorum to allow a functioning sentencing commission would be reestablished soon. You're an exceptionally well-qualified, diverse slate of nominees with impressive backgrounds that will suit you well for this important role. Too often our conversations more broadly about criminal justice reform accept what I think is a false premise, namely that anything that helps criminal defendants get their lives back on track should somehow be equated with being soft on crime. I think that's exactly wrong, and I appreciate my colleagues on the other side of the aisle who share the view. I am proud to lead with Senator Cornyn of Texas the Begin Again Act, a bill that would narrowly expand the availability of federal expungement for first-time drug offenders that passed this committee by a strong bipartisan vote last year. I'm also excited to be working with Senators Lee and Cornyn and others on a bill to reform federal supervised release to ensure limited supervision resources are allocated to those who would most benefit from them and to create some positive incentives that would encourage returning citizens to take the steps needed to rehabilitate themselves and stay out of trouble. So I have two questions, if I might, to follow up on this. Judge Gleason, you were known as a federal prosecutor, some would say a hard-nosed federal prosecutor. In Brooklyn, you led the prosecution and conviction of John Gotti. You are no stranger to the concerns of victims and the need to protect public safety vigorously. Based on your experiences as both a prosecutor and judge, can you describe your views on how tools like expungement or the creation of positive incentives for those who've left prison can be ways to actually improve public safety?
Yes, thank you, Senator. Thank you, Senator. There's potentially a very long answer to that question, but I'm going to give you a short one. And that is that we have a criminal justice system that is increasingly attentive, as Judge Restrepo has already testified, to the needs of people in reentry. And then there are also I think one of the next big things in terms of criminal justice reform subjects are the collateral consequences of convictions. They are impossible to overstate. I wrote an opinion once saying that I sentenced someone to 5 years of probation, not a lifetime of unemployment, and wrote about the need in limited circumstances for expunction. It's a topic I respectfully suggest belongs in the first instance in this body, requires a great deal of study, needs to be data-driven, as Senator Grassley has mentioned earlier, but I applaud you, Senator Coons, for raising it because it's one of the next, there's plenty of current big things in criminal justice. I believe expunction and other forms of assisting people in dealing with collateral consequences is hopefully one of the next big things in criminal justice.
Well, thank you, Your Honor. I ran a youth program in the east side of Wilmington nearly 30 years ago now. And over the arc of the lives of the then young people now in their 40s who I've followed, the lifetime consequences of one early conviction, particularly in a town where there's a lot of financial services and thus the barrier to being hired is particularly high for anyone who has a conviction of any kind, how it has locked them out of meaningful employment for decades. Has been something that struck me in terms of the collateral consequences for their families of one conviction. Judge Restrepo, if I might, I understand you helped create a reentry program in the Eastern District of Pennsylvania known as STAR, Supervision to Aid Reentry, that was focused on individuals with a history of violent crime or a significant risk of recidivism. Can you describe what you learned through that program about how to better support reentry, especially for those who've committed heinous crimes, and how that relates to improving public safety?
Thanks for the question, Senator. Our program is all about public safety and reducing recidivism. And it's really a very collaborative effort between the United States Attorney's Office, the Department of Justice, the federal defenders, the defense bar, and a lot of local partnerships that we've grown organically through Drexel University, Temple University, that provide services such as cognitive behavioral therapy, financial literacy assistance, housing assistance. So it's a very multifaceted approach that we've taken to helping folks come home and become productive citizens. There's no simple path, and as Judge Gleason has identified and you've identified, there are a lot of barriers to successful reentry. So at the end of the day, our program takes individuals and we meet them where we find them and try to help them make a successful transition from being in custody to being a productive citizen.
Thank you, Your Honor. And thank you to all of you. Thank you for your willingness to continue your service. I look forward to supporting your confirmations and hope that we can advance all of your confirmations and return to having a functioning sentencing commission. Thank you, Chairman Durbin.
Thank you, Senator Hawley.
Thank you, Mr. Chairman. Thanks to all of the nominees for being here. Congratulations on your nomination. Ms. Mate, if I could start with you, would you agree with me that child exploitation crimes are serious crimes?
Thank you, Senator. Yes, I agree.
Would that include child pornography offenses?
Yes, Senator.
Do you think that those offenses and the child pornography epidemic, is it getting worse? Is it getting better? Is it lessening? Is it gathering steam? What's your understanding?
Thank you for that question, Senator. I don't know the answer to that right now. I haven't looked at the data on that. If I'm fortunate enough to be confirmed as a commissioner, that's certainly one of the things we could look at.
Didn't you sign a letter in July of 2013 in which you argued that the child pornography guidelines were too severe? Is that right?
Thank you, Senator. That letter from 2013, many years ago, was drafted by the defenders and as part of their role in commenting on the work of the commission.
You say they, but that was you, right?
I was one of the...
You signed it?
Yes, I did.
Okay, so in the letter, you criticized the current child pornography sentencing guidelines, saying that they result in overly severe guideline ranges in nearly all cases. Is that still your view?
That was the defender view at the time. If I'm
But you
confirmed,
signed the letter, right?
I did in 2013.
Okay. Right.
And
that's my question. So you've changed. Sounds like you've changed your mind.
I don't have an opinion on that right now, Senator. I would want to look at the data and get up to speed on where things are right now.
You had an opinion in 2013, so you're saying that now you don't have one?
I'm saying that I would want to offer you an informed opinion, and things change over time. That was a long time ago, and
Oh,
I would
indeed.
certainly want to look at
Indeed, they do. You said a number of frankly alarming things in that letter, including saying that you reject the view of some commissioners that a mandatory minimum penalty is ever needed, ever, or appropriate in child pornography cases. Ever. So you said you weren't familiar with the facts. Let me just rehearse a few of the facts for you. According to the New York Times, in 2018, there were 45 million online photos and videos of children being sexually abused. That was more than double the number from the previous year. Then the National Center for Missing and Exploited Children reported that in 2021, that number had risen to 85 million. So from 45 in 2018 to 85 million photos, videos of children being exploited online, a huge increase in just the space of those very few years. Now, I don't know about you, but that sounds to me like an epidemic. So in light of that, do you still think that parents' concerns with this exploitation of children involves exaggerated fears based on lurid stereotypes and a widespread misunderstanding of the nature of these offenders? That's from your letter.
Thank you, Senator. As a parent, I'm concerned about these images. If I'm lucky enough to be confirmed as a commissioner, I would want to carefully examine all of these issues. The offenses, our statutory obligation as commissioners is to consider all the purposes of sentencing, to gather data, research, and information, and make informed recommendations. And I would want to collaborate with commissioners in making those recommendations.
Well, I'm trying to get a sense of what your policy preferences are. This is a policy-making role. It's a policy-forming role. You had previously said that you thought no mandatory minimums were necessary or appropriate in this context. In light of this data, is that still your position, that you think that no mandatory minimum sentences for these crimes of exploitation against children is appropriate?
If I'm fortunate enough to be confirmed
I
as a
think
commissioner,
that's probably
Senator,
a yes or no answer.
Well, I wanted to say, Senator, is that if I'm confirmed, my obligation as a commissioner is to pass guidelines, amend guidelines
I understand
that
what
are
your role is.
consistent.
I'm looking for a yes or no answer. You're not being confirmed to the bench. I'm not asking you to comment on cases that may come before you. You're being confirmed to a policy-making position, and this is deadly serious policy. So I'd like to know, you've taken a position on this. I want to know if you've changed it. Have you changed your position, yes or no?
I don't have a position on mandatory minimums.
You
That's
did have a
decision.
position in 2013. You signed a letter. I've read it to you now multiple times. Senator Blackburn read it to you. I'm looking for a yes or a no. Have you changed your position, or do you still believe that there shouldn't be mandatory minimums for these kinds of crimes against children?
I believe that there are mandatory minimums.
Should
against
there
this
be
crime.
mandatory minimums? I know what the facts are. I'm asking you what your view is, and you're not answering me. Are you not going to answer, I gather?
I believe it's really important in entering this position with the Sentencing Commission, if I'm confirmed.
Are there
with my
any crimes
colleagues
for which you would support a mandatory minimum? Because you've also said that you think that the commission ought to change the sentencing guidelines to allow judges to depart from mandatory minimums upon considering the various 3553A factors, which would get all mandatory minimums. Is there any crime for which you think a mandatory minimum is appropriate?
Thank you, Senator. My understanding is this body decides whether there are mandatory minimums, and as a commissioner, my job would be
You make
to follow
recommendations. I'm asking you if you think that there's any crime, rape, for which there ought to be a mandatory minimum, because you said earlier there shouldn't be. I'm astounded by that.
Thank you, Senator. If I'm confirmed, I'd like to make an informed recommendation on that after consulting.
How am I going to make an informed judgment on voting for you if you won't tell me what your positions are? I don't know if you changed them or not. It sounds like you have changed them. You signed a letter. You took very frankly radical policy positions, and now you won't answer me. What am I to draw from that?
Senator, I hope that what you draw is that I'm open to listening to this diverse group
No,
of
I think what I
people.
draw from it is that you don't want to answer my questions, because the positions that you took were radical and frankly, I think wrong. And in light of the dangers that children and people all over this country are facing, I think deeply, deeply wrongheaded. I can't possibly support your nomination. I can't support the nomination of someone who wants to do away with mandatory minimums. I think it's a radical position, and I think, frankly, your nomination is indicative of where this administration is on its soft on crime policies. Thank you, Mr. Chairman.
The questioning by Senator Hawley may sound reminiscent of his questioning of the Supreme Court nominee, Ketanji Brown Jackson. and we know his position. We also know his approach to questioning about this issue. I might call to his attention, and I hope he has read carefully, the report of the Sentencing Commission on this topic. It suggests that we have a responsibility in Congress to do something, having waited for years and not responded to changing circumstances for this horrible crime. We need to do this in a thoughtful way, and I hope we will.
And indeed, Mr. Chairman, you may recall that I've introduced legislation to do that, which you personally blocked.
Listen to how he did it. Brought it to the floor, take it or leave it. This is an issue that is serious, and we ought to treat it seriously, which means we deal with our responsibility as a committee, not to jam it through on a take it or leave it.
Well, I look forward to you marking it up then.
Well, I look forward to you suggesting some alternatives other than just put everybody in jail. There's got to be a better approach.
Right. Let them all out.
No, of course not. And that's the kind of conversation we have here, unfortunately, instead of getting down to the serious business. I would recommend the introduction to the Sentencing Commission report of a year ago, which acknowledges the obvious. Child pornography offenses have grown substantially. There's a steady increase in the percentage of sentences imposed below the applicable guideline. Over 60% of the judges have said that the guideline does not reflect reality. And third, the volume and accessibility of child pornography images has increased dramatically. This is a serious, horrible crime. We need to treat it as such, and we need to treat the topic as a serious undertaking by this committee, not drive-by questioning and suggestions on the floor of the United States Senate. Senator Ossoff.
Thank you, Mr. Chairman, and congratulations to the nominees. It's an honor. Appreciate all the service you've all rendered to the country already, and thank you for sitting before the committee today. Ms. Wong, if you would please, what in your view is the purpose of punishment?
Senator, the purposes of punishment are fourfold: deterrence, incapacitation, retribution, and rehabilitation. And those are also enshrined in the 3553A factors.
Mr. Gleason, Judge Gleason, rather, talk a bit about your perspective on and experience with deterrence. When does it work? When doesn't it work? How does it work? And based upon the sentencing decisions you've made, how have you applied that experience?
When it comes to general deterrence and a purpose of sentencing to try to deter others from committing crimes, that's an issue that vexed social scientists, Senator, for a long time. It's very hard to measure. My own view is there are certain types of crimes where it's not fanciful for a sentencing judge to think that other folks who might be considering that crime are paying attention. So this, what's called in the literature, exemplary punishment, sometimes is appropriate. If only we could measure general deterrence, we'd have a better yardstick by which to formulate sentencing policy. I actually believe in general deterrence in the abstract. Would that we could measure it. And one of the great things, as Senator Grassley pointed out at the outset of this hearing, is this body should be driven by data. And to the degree that advancements in human knowledge, to use the language of the Sentencing Reform Act, that affect federal sentencing policy include advancements in knowledge about what works in terms of deterrence, that's something that, if I'm fortunate enough to be confirmed to this commission, would be something that I would pay very close attention to along with my colleagues.
Thank you, Judge Gleason. Judge Boom, based upon your experience on the bench, how have you tended to consider violent versus nonviolent offenses in the context of deterrence, retribution, incapacitation, rehabilitation? What do you think is the importance of the distinction?
I think that the tools that Congress has given us in the guidelines and in the 3553A factors inform judges in making those determinations, specifically with respect to violent offenders and nonviolent offenders. I've never studied the academic issue of deterrence theory. I do believe in general deterrence, and I believe in specific deterrence as well. I think another aspect, in addition to what Judge Gleason has outlined, is fashioning additional supervised release conditions that can also affect deterrence. But as a general matter, I think certain crimes are more likely to be deterred through sentences than others.
Thank you, Judge. Judge Restrepo, let's talk about incapacitation as a purpose or function of punishment. What does it mean to segregate from society those who pose a threat to public safety or from the public, and how do you strike the balance appropriately?
Thanks for the question, Senator. It's a difficult balance, but I would agree that if the question is, should some people be segregated? Yes, some people do need to be segregated. They're the exception, I would suggest. And again, consistent with what you heard from my colleagues, you take a look at the guidelines, the congressional intent, and if there are any mandatories, the 3553A factors, conversations with probation, recommendations from probation, the arguments of counsel. But I guess the short answer to your question, Senator, is yes, some people do need to be segregated.
Ms. Murray, what in your opinion is working in the U.S. sentencing regime and what's not?
Well, I think that the balance, we've come into this new era, not so new anymore, where we have guidelines, and we've come out of the old era of sort of law without order. So now we have a balance between direction that is given on a sort of wholesale level where we have the guidelines, but also there is individual discretion where judges can vary from the guidelines or depart or work within a range. And I think that is working in terms of balancing the need to treat offenders alike and also to focus on individual aspects of individual defenders.
Thank you, Ms. Murray. And Ms. Mata, you just had an extensive and vigorous exchange with Senator Hawley, and my time is short, so I mean no disrespect in turning my attention now to Judge Reeves. But Judge Reeves, I'd like to get your view on and your experience with the significance of firearm possession in a suspect or a criminal who is carrying a weapon in the commission of a crime, but does not engage in violent acts in the commission of a crime. This is obviously a enhancing quality of certain criminal acts. What, in your experience, is the value of considering that when making sentencing decisions, either when Congress establishes guidelines or when you as a judge exercise your discretion? What else do you think we need to be thinking about as we weigh the relevant law that pertains to possession in the course of a nonviolent offense, firearm possession? Thank you.
Thank you for the question, Senator. In that regard, I have imposed those certain enhancements because the law required to at least look at those, to consider those enhancements. And in an individualized assessment of that particular defendant, we've adjusted the sentence that might have been imposed for the individual, despite the fact that he had a weapon, sometimes because of the individual circumstances, because of who that particular individual is at that particular time that he or she had the weapon, factors into what sentence that person might get on that enhancement.
Well, thank you, Judge. And Mr. Chairman, thanks for the indulgence. I'll just say to you all, communities in Georgia are deeply concerned by the state of public safety in many of our communities, and equally committed to ensuring equal justice for all and that the civil rights of all Americans are upheld. We have to achieve both of those ends, and within the proper constraints of your roles on the commission, should you be confirmed, I hope that you'll endeavor to do so. I thank you again for your service, and I yield.
Thank you, Senator Ossoff. Before recognizing Senator Booker, I'd like to make a statement. As we met here this morning, news broke that a man was arrested near Justice Brett Kavanaugh's Maryland home carrying at least one weapon and burglary tools. He told the police he wanted to kill Justice Kavanaugh. Yesterday, the committee held its third hearing to examine the growing threat of domestic terrorism. FBI Director Wray has warned us that this threat is, quote, metastasizing and not going away anytime soon. In the past few years, this metastasizing threat and the growing use of political violence has endangered elected officials, police officers, flight attendants, school board members, election workers, and other public servants. As, let me be clear and unequivocal, threatening and using violence against public officials is never acceptable. I know I speak for every member of this committee when I say that this individual should be investigated and prosecuted to the fullest extent of the law. I'll be asking the FBI and Department of Justice for an update on this troubling incident, and I will keep working on this committee to combat domestic terrorism threats, whether they emerge from the right or the left on the spectrum. That is irrelevant. Violence is never acceptable. Senator Booker.
That's really sobering information. I appreciate your comments, Mr. Chairman. And I appreciate some of your comments at the top of the hearing about how we are evolving as a society and understanding about a lot of the harsh penalties that came out of the so-called war on drugs need to be reexamined and relooked at. I'm really honored to sit before a bipartisan panel where you in many ways could set an example for our country about the need for us to come together across partisan lines and the terrible tribalism that seems to be gripping our nation and begin to move more towards common sense and comedy. And I'm just grateful for all of you and your willingness to serve. Mr. Reeves, I'm most partial to you just because of your haircut. But I just want to ask two clarification questions to Ms. Wong and Ms. Murray. And Ms. Wong, just to start with, you're currently an assistant U.S. attorney at the U.S. Attorney's Office for the District of Columbia. Thank you for your willingness to serve in such an important law enforcement role. And you're serving now as the Chief of Violent Reduction and Trafficking Offenses Section. You would continue to be employed by the Department of Justice in this role as a prosecutor while you hold this important position on the Sentencing Commission. And could you maybe, for a lot of people that might have some concerns, talk about what measures you might take to avoid what might be a perception of conflict, and then help to create whatever the reasonable wall is between your work on the commission from your daily work as a prosecutor? And do you believe that there are or might be some inherent conflicts of interests, given the commission's policies will have a direct effect on the cases that you're dealing with?
Thank you, Senator. Should I be fortunate enough to be confirmed to this commission, the role to which I've been nominated is by statute a part-time position. My hope would be to continue to serve as an assistant United States attorney if I am so able. But what I would stress, Senator, is that should I be confirmed, I would pledge to approach the work of the commission as my own person and not as an employee of the Department of Justice. And nothing about my experience as a prosecutor would preordain how I consider or tackle any particular issue. I would stress, of course, that while I'm very proud of the work I've done for the Department of Justice over the last 7 years, that I bring a well-rounded set of legal experience to the table. I've served on the defense side in private practice. I undertook numerous pro bono representations in criminal cases for criminal defendants. I also bring to bear my experience as a judicial law clerk on the D.C. Circuit and the Supreme Court, and also, of course, my service as an ex officio commissioner on the commission from 2020 to 2021. So I bring all those experiences to bear should I have the opportunity to serve.
And Ms. Wong, just from my own understanding, are there circumstances where there might be a conflict of interest between the two, dealing with an issue that might be in a case in controversy that you're involved in and your work on the Sentencing Commission?
Senator, I don't see a conflict any different from the judges that have served on the commission while continuing to adjudicate over sentencings or defense practitioners who continue to practice. But I would, of course, consider any kind of ethical issue on a case-by-case basis.
Because a judge's role is sort of to be a independent viewer of two sides that are, by their very nature of their job, advocating for positions. And so it is a little bit different than a judge. Am I correct?
Senator, I don't, as an AUSA, my interaction with the guidelines is typically a computation, much like what the probation officer prepares as to where, under a criminal history category and offense characteristics, a defendant appears. But what I can pledge to you is that should I have this opportunity, I would not prejudge any kind of issue based on my prior experience.
I'm grateful for your pledge. I'm really grateful. Ms. Murray, again, thank you for your willingness to be here and step forward for such an important role as well. I just want to focus in and give you a chance to maybe talk about a 2003 article where you equated people who agree that fetal homicide should be a crime and who also support a woman's right to have an abortion as, quote, saying that one person's humanity depends upon the judgment of others. You go on to say, quote, ever since the Holocaust, people have been a little wary of that sort of thing. And I'm just wondering if you might want to clarify, do you think it's appropriate to equate the Holocaust with people who support the right of a woman to access abortion care?
Oh, thank you so much, Senator. That's not what I was saying, or at least what I was trying to say. That's a student piece, as you know, that I wrote 20 years ago.
I didn't know that. My staff just gave me this quote. So
it's a piece I wrote in college, a short squib, and the idea was just that there was a.
Where'd you go to college?
Harvard College.
I haven't heard of that school. It's the Stanford of the East. Continue, please.
It's a 4-year school.
It's a 4-year. Okay.
I was trying to draw out a sort of philosophical tension sometimes between the idea of supporting fetal homicide laws and then being pro late-term abortion. So the idea would be that the life of the child shouldn't depend on someone else's view of whether the child is wanted. It's, I think, really important that our humanity is not determined by what other people think of us. And the idea was that that is a bad principle in general and a principle that was involved in other really bad things.
Right. And like me, I hope that my intellectual thinking on issues has evolved since I was in college. I don't know about you.
Yeah, for sure.
Okay. And so you might, for the record, you want to say something. What would you say to people? This is obviously a big issue right now in the public thought and concern. We all have to find ways to give assurances to each other that in positions of power like you'll be in, that you'll be able to be to separate your personal views, perhaps, from your duty and from your work. Do you want to say something in closing to those who might be concerned about that?
No, absolutely. Thank you. If I were so fortunate as to be confirmed, my guiding light in all commission work would be the law of the land. And, the law of the land is defined by this court, by this body, and also by the Supreme Court. And I would not see myself as bringing my independent policy views, other than certain evidence-based sentencing views coming directly from research, to that work. I would see myself as guided by this body and by other law of the land.
Thank you very much. Mr. Chairman, I just want to say again, thank you to you. You and I have worked on issues around sentencing for a very long time. And I think that we live in a nation that is apart from the rest of the world in how much we throw people into prison for very long periods of time, how much it disproportionately affects Black and brown people, survivors of trauma, the addicted, as well as the mentally ill, as opposed to a nation that does the things that help people. We often put them in environments that hurt them more and have them be released from prison in ways that have them harm themselves or their community or end back up in prison. And so I just am grateful for your leadership on this and framing this conversation in a way that I hope can help empower the Sentencing Commission to do its job and move more towards a system not of retribution but of restorative justice.
Thank you very much, Senator Booker, and we'll continue that work together.
Thank you.
I have Senator Cruz has arrived, and we go from Democrat to Republican. I'll recognize him once he's seated, and then Senator Whitehouse.
Thank you, Mr. Chairman. Welcome to each of the witnesses. Judge Gleason, I'd like to start with you. In the past, you've written that in drug trafficking cases, you would consider all of the 3553A factors other than the sentencing guidelines because they're too harsh. If this is the view that you hold today, what is to stop other judges from likewise ignoring the guidelines that you end up producing as too lenient?
Thank you, Senator. No, judges don't ignore the guidelines. They're required to consider them, as I did after Booker was decided in 2005. Every sentence began with a computation of the guidelines. It's true in that Diaz case that from which your question emanates. I expressed the view that the linkage of the guideline ranges to the drug types and quantities that drive the federal drug offense mandatory minimums was, in my view, in that opinion, a policy decision with which I disagreed pursuant to the authority conferred on me by the Supreme Court as a district judge in the Kimbrough case. That was my view in that case. I don't shy away from that. My view is I've got a different role if I'm lucky enough with this distinguished panel to be confirmed to the Sentencing Commission. The views of the Sentencing Commission represent the consensus, the vote of a body that's designed to listen to everybody, all the judges, the prosecutors, probation, defenders, all the stakeholders. Take all of those views into account and formulate sentencing policy as an entity, as a bipartisan entity. Do I bring those views with me to the table? Of course. In my view, do they play a role in the decision-making of this commission if I'm fortunate enough to be confirmed? Not really.
So all across the country, Americans are deeply concerned about the rise in crime we're seeing, the rise in murder rates we're seeing, the rise in carjacking rates we're seeing. That rise in crime is a direct result of policies from the radical left to undermine the police, to defund the police, to try to abolish the police, and radical prosecutors who refuse to prosecute violent crime. Just last night, we saw a rather remarkable outcome in that the voters of San Francisco, bright blue, liberal San Francisco, just recalled their district attorney because they got tired of a left-wing DA releasing criminals over and over and over again. When you've gone too far left for San Francisco, that's a pretty good sign that you have lost sight of the American people. Now, on the bench, you have been very critical of long periods of incarceration for drug traffickers. Before this committee, are you prepared to acknowledge the extraordinary harm that drug traffickers do to communities around the country, and especially in my home state of Texas, which is facing a completely unprecedented border crisis because the Biden administration refuses to enforce our laws?
Of course I'm willing to acknowledge the extraordinary harm drug trafficking does in your communities in Texas, in ours, in New York. It is a deadly serious crime. The last thing it is, Senator Cruz, is a victimless crime. There are victims all over the lot. It's a scourge of some of our communities in New York. I'm with you completely on the seriousness of that as a federal felony.
Several years ago, you argued that the United States criminal justice system is disproportionately harsh compared to other developed countries. As a commissioner, would it be your objective to make our criminal justice system more lenient, less harsh, more reflective of the criminal justice systems of other nations that you have pointed to as being more lenient?
No, that's not my goal coming into this as a hopeful, confirmed nominee to the Sentencing Commission. My goal is to do what this body created the commission to do, which is to formulate, to the degree that the commission formulates policy, much of the criminal justice policy emanates from this body, from the Senate, from the Congress. But to the degree that the commission itself formulates sentencing policy, it should be driven by advancements of human knowledge as they relate to criminal justice, data, collaboration, listening as the commission is required by statute to do, to DOJ, to defenders, to the Judicial Conference of the United States.
Have there been advancements of human knowledge as to the harms of violent crime?
Not to my knowledge. There's been some advancements of human knowledge in recent years that I regard as very important. That's not one of them, though, Senator.
Thank you.
Thank you.
Senator Whitehouse.
Thank you very much, Chairman, and thank you all for your willingness to serve. Ms. Murray, I have some questions for you that relate to your experience in the White House Counsel Office. You served in the White House Counsel Office during the time that Justice Kavanaugh's Supreme Court confirmation took place. Is that correct?
That's correct, Senator. I also clerked for him.
Were you involved in the confirmation effort at White House Counsel for now Justice Kavanaugh?
I was, Senator.
Can you describe what role you played in White House Counsel for that confirmation effort?
I was one of the people who helped him to prepare for his initial hearing.
Murder boards and things like that?
Lots of moots, lots of binders, lots of,
Yeah.
yeah.
Anything else?
That was the main thing.
Were you at all involved in or read into the FBI initial background investigation of then Judge Kavanaugh?
No, the White House Counsel's Office has a team that deals with background investigations that are kind of separate for reasons of confidentiality and privacy. I was not.
Who was? Do you recall who was in that White House?
It would have been those
group
nomination. It would have been those background people who I think
who were
the committee.
I don't know who they were. Do you recall any of the names of the individuals who were part of that group? Who led it, for instance?
I'm sorry, Senator. I'm not really comfortable giving the names of other people and their work. It doesn't feel appropriate. I'm sorry.
The people who led the White House Counsel effort regarding a background investigation, you're not comfortable? Do you know who they are?
I mean, presumably the leader of the entire effort would have been the White House Counsel, who at the time was Don McGahn.
Yes, but you said there were separate groups, so I'm wondering who led that group.
So I don't know who worked on this in particular. I can tell you that the background investigation team, who I think this would be known to you or your staff because they came to brief the Hill frequently, and I don't know who was doing it at this time. There would have been Jim Carroll, Renee Augustine, Dino LaVerghetta. There was a largest team who came to brief the Hill on these matters.
And later on, when the FBI had to conduct a supplemental background investigation, were you involved in that effort at all?
I was not, and I didn't have much visibility into that effort either.
Same thing that was done by the group within White House Counsel who handle background investigations?
I actually don't know who was handling that, if it was that same group, or I don't know who was handling that.
Do you know what the FBI's role was in that supplemental background investigation compared to White House Counsel's role?
So we were kept pretty walled off from all of this. My sense is that they were doing the investigation. Counsel's office would not have done any investigation.
Your sense is that the White House Counsel's office would not have done the investigation, that the FBI would have done the supplemental background investigation?
That's right, because counsel's office is only lawyers. It's not investigators or agents.
Yeah. Do you know what the role was of White House Counsel's office in directing the FBI investigation of the supplemental background investigation?
I don't, and at the time I would really have liked to have known because I was very curious, but it was kept separate from the team that had helped with the hearing preparation.
Okay. So if we had information that the supplemental background investigation was actually run out of White House counsel's office, and that the FBI was not following any standard procedures or protocols, but was in fact taking direct, full direction from White House counsel in that background investigation, you wouldn't have any information about whether that was right or wrong.
I'm sorry.
Okay. Do you recall having any contact with our committee during that process?
Not with, certainly that I was present at the hearing.
Yeah.
There were, I think there were staffers who, led us to the rooms that we were going to be in, that we were going to work out of. I was not a sort of hill-facing staffer. There certainly were staffers, I'm sure, who were interfacing with staff. Well, not a group so much, but I was like the law person. I was the Supreme Court clerk, not the person who had Hill experience.
Yeah. Okay. Well, my time is up. Thank you for your testimony. Thanks, Chairman.
Thank you, Senator Whitehouse, and thanks to the panel for your patience and your family and friends as well. Our nominees appear before us today are to be congratulated. Please be mindful that senators may submit written questions following the hearing. We ask you to diligently respond in a timely fashion. The deadline to submit these questions is 5 p.m. on Wednesday, June 15th. The record will likewise remain open until that time to submit letters and similar materials. And with that, the hearing stands adjourned.